I'll turn to the next case on this morning's docket. That is case number 104998, State of Kansas Appellee v. Miguel A. Garcia, appellant.
May it please the Court. I'm Deborah Wilson. I'm appearing today on behalf of the defendant appellant Miguel Garcia. Justice Ness, I'd like to request 3 minutes rebuttal time.
3 minutes is granted.
Thank you. Mr. Garcia was convicted of felony murder and conspiracy to commit aggravated robbery in connection with the fatal shooting of Andre Arteaga Vega. He's currently serving a life sentence. All witnesses to this crime agree that it was the co-defendant, Alil Fernandez, who shot the victim, Mr. Arteaga Vega, and in the process shot Mr. Garcia as well as he was trying to get the gun away from Mr. Fernandez. The question for the jury to determine in this case was whether Mr. Garcia willingly and knowingly associated himself with Mr. Fernandez's attempt to rob the victim. Which brings up this question, the question of the evidentiary value of the gruesome and repetitive autopsy photographs that were introduced in this case to show the path of the bullets that Mr. Fernandez fired. These photographs are the subject of the third issue in this case, and although this court rarely finds error in the admission of autopsy photographs, this case presents an extreme example of a trial court failing to exercise discretion in determining which photographs should come in, and instead ceding that discretion to the pathologist to make that determination. In this case, because Dr. Mitchell said, well, all these photographs will help me define what injuries occur, every single photograph came in. I'd like to call the court's attention to Exhibit 188 in particular. This was described by Dr. Mitchell as surgical wounds with abdominal contents pulled through. And those words simply do not do that image justice. Mr. Arteaga Vega has been disemboweled in this photograph. He's been split open from the bottom of his rib cage to his pelvis, and his intestines and other organs have been pulled out and piled on top of him. It's a very disturbing image, but more importantly, the gore in this picture has absolutely nothing to do with the wounds that Mr. Fernandez, not Mr. Garcia, Mr. Fernandez inflicted on Mr. Arteaga Vega. And the state's made no effort in their brief to explain how this image could have possibly helped the jury in this case understand whether Mr. Garcia was a willing participant in Mr. Fernandez's robbery attempt. In fact, even if this were the shooter's trial, even if this were Mr. Fernandez's trial, the photograph would have no evidentiary value because all it did was just depict the damage done by Dr. Mitchell. There wasn't even a gunshot wound shown in this image. Now, I admit...
Should there be a distinction between the photos that are allowed in on the shooter as opposed to the co-defendant?
You know, this court
and why?
Yeah, I'll tell you, this court has always said we treat autopsy photos differently from scene of crime photos or crimes that simply depict, no matter how gruesome, the damage that the perpetrator inflicted on the victim. Now, I know there are a lot of cases where this court has allowed even pretty gruesome, pretty graphic autopsy photographs where you are depicting a lot of damage from the autopsy, but usually the reason for that is well, these photographs show the path of the bullets or what sort of damage the bullets did, and that helps us understand the state of mind of the shooter. And of course, in this case, Mr. Garcia wasn't even the shooter. And of course, the question of state of mind in this case was, did he know there was going to be a robbery attempt, and did he associate himself with that?
Well, no, I mean, you're suggesting that autopsy photos are are admitted based on the state of mind of the shooter? Isn't it to show cause of death, typically?
Well, frequently, when you have autopsy photos where, for example, organs have been removed and there are rods going through them. I remember discussions about rods going through people's brains and those sorts of things. And when defense counsel complains, this is the gore here is the pathologist doing. Oftentimes this court will say, well, it actually had some evidentiary value because it showed, for example...
I think what Justice Rosen's getting at is whether there's a distinction between whether you have a murder, an intentional murder, or if you have a felony murder, because, for instance, this victim could have died of a heart attack during the perpetration of a robbery, and if the robbery was a causal connection with a heart attack, then that's felony murder, right?
And here's what the state, or here's what Dr. Mitchell could have done. Here are the 2 bullet wounds that went into his torso. Here are where the 2 bullet wounds came out. And here on this chart, we see the path of the bullet. We see that it went through the liver or it went through another vital organ. And I determined the cause of death to be bullet wounds that went through and through the victim's torso. And defense counsel, of course, offered to stipulate to the cause of death in this case. And even if we consider those things necessary, remember, Exhibit 188 didn't even show a bullet wound, and Dr. Mitchell didn't even refer to it in his testimony when he was explaining the cause of death. It was just the victim disemboweled on the slab in the autopsy room. Now, 188 is the worst exhibit, which is why I'm talking about it today, but it's emblematic of the fact that there were many, many autopsy photographs offered in this case, many of them repetitive in a series of photographs, basically where, okay, I've cut the victim open and now I'm removing the contents of his chest, organ by organ in this case. And none of these photographs shed any light on the fact that the jury needed to determine what was Mr. Garcia's state of mind, because he in this case didn't shoot anyone.
Which exhibits were objected to as far as admission? Wasn't it 175 and 176?
No, there was a whole string of exhibits that were objected to. And if I could on rebuttal, I'll give you the cite to that. I'll make a note to do that. I'd like to turn to the admission of Mr. Garcia's confession, a confession that he repudiated at trial. Sometimes when people have been cleared of crimes that they have confessed to, they're asked the question, why did you confess to something you didn't do? And frequently the explanation they give is, I just wanted the questioning to end, so I told the police what they wanted to hear. I think if there was ever a situation conducive to wanting the questioning to end and telling the police what they wanted to hear, it would be having an untreated bullet wound in you, having your request for medical attention either ignored or put off, and finally being told you'll get medical attention when we're done questioning you. And that's what happened in this case. Now, the state's position is that Mr. Garcia wasn't in much pain, so this wasn't really any big deal that they were putting off getting him medical treatment. And the state says in their brief, Garcia voluntarily refused medical treatment for 9 hours. Well, not really. Mr. Garcia wasn't in the hospital saying, oh, I don't need any treatment. Mr. Garcia was hiding. And the fear overcame his pain in this case, but this does not equate to voluntarily refusing medical treatment. And in fact, once in custody, he repeatedly asked for medical attention and asked for something to alleviate the pain. And I have to quibble a little bit. The state has suggested to this court that when Mr. Garcia said, I don't feel it, he was expressing to the police officers that he wasn't in any pain. When you look at this statement in context, it's clear that he didn't feel the bullet. That's what he was telling them.
Didn't the district court make findings on this issue? And could you tell us what is wrong with or why the district court was wrong in that determination? I mean, she addressed this very issue that you're
Right.
telling
Right.
us. And
Well, first of all, that actually brings up the question of the standard of review. And in this case, I've suggested that this court can exercise de novo review. And that's because the only evidence, there was no testimony, there was no argument in this case. The only evidence regarding the voluntariness of Mr. Garcia's confession was from the videotapes or the CDs that the district court viewed. And those are part of the record. So this court is in as good a position as the district court to determine whether or not Mr. Garcia's pain was of such a level to overcome his will and render his statement involuntary. And I think that...
But that's a factual determination, and we've got some case law that says we just don't find facts. Even if we could, even if we're in as good a position, we have some case law that says that's a district court function. And we review facts or review evidence to support facts, but we don't make those factual facts.
And actually, you also have case law that say when we are in as good a position to make a factual determination, we'll exercise de novo review. There's case law in Kansas, not on this exact scenario, but I've cited cases to you from other jurisdictions where the courts have done exactly that. They viewed a video of an interrogation and they've made their own factual determinations. And let's stop for a moment and think about this. What a weird calculus that the state is asking this court, or the district court for that matter, to engage in. The state actually wants us to think about the question of how long the police can withhold medical treatment from a person who is in their custody before a statement is involuntary. How much pain can the accused be required to bear before his statements are involuntary? Mr. Garcia didn't have a paper cut. He had an untreated bullet wound when he made his statement. And very quickly, let's add to these circumstances, the police officers promised to Mr. Garcia through the girlfriend, Imam Malkawi, just confess to robbery and you will not be charged with murder.
Booked. The girlfriend says, tell him you did the robbery and you will not be booked for murder. And there's a distinction between being charged and being booked, isn't there?
Well, Justice Johnson, I did not pick up on that distinction, and I doubt that Mr. Garcia would have picked up on that distinction either. I think that...
But he had some prior involvement with law enforcement.
As do I.
And so when the girlfriend says you'll be booked for robbery, you will not be booked for murder, that would have carried the reasonable expectation that Officer Vole, who was sitting there, had that discretion. Because an officer can book someone in for any crime for which there's probable cause, correct?
Yes, but that's a very interesting distinction you're making, and frankly, I've been practicing criminal law for decades now, and it certainly wasn't a distinction that I picked up on, and I probably have a little more experience with criminal law than Mr. Garcia, and so I think it would be very interesting for this court to find that because the promise was what you'll be booked on rather than what you'll be charged with.
Actually, that cuts in your favor. That cuts in your favor because the state's making the argument that there was not a reasonable expectation that the girlfriend or the officer had charging authority.
Oh, I see what you mean. I see. That's a very interesting point. That hadn't occurred to me.
Can I move you real quickly
Yes.
to the rebuttal witness?
Yes.
If your client had simply not taken the stand, then that witness wouldn't have been able to testify. So why doesn't taking the stand and denying voluntary participation in the robbery bring that back into play?
Because the law of curative admissibility requires that before you open the door to this previously inadmissible testimony, you have to take unfair advantage in some way of the witness's absence from the trial. And I was trying to think about because I don't think that taking the stand and saying, I didn't do it and I didn't know anything about the robbery, just that in and of itself doesn't open the door. Because if that did, it's my position a plea of not guilty would actually open the door to that. So I was trying to think of a way, how could Mr. Garcia have taken unfair advantage of Markel dos Santos's absence and thereby open the door for the state to say, oh no, you have misrepresented what happened. And I thought, if he had pulled Mr. Markel dos Santos into his testimony in some way, for example, if he had said, Markel dos Santos asked me, are you going to rob someone tonight? And I said, no, robbing people is wrong. I would never do that. Or if he had said, Markel dos Santos heard me say to Mr. Fernandez, don't take your gun out tonight. Leave your gun at home because we don't want any trouble. But in this case, Mr. Garcia's testimony was exactly the same as it would have been if Markel dos Santos had testified in the state's case in chief, which is, I didn't plan a robbery, I didn't know there was going to be a robbery. So he in no way took unfair advantage of that witness's absence from the trial.
Except that if he says, I didn't plan the robbery, and the witness is going to be able to testify that he did overhear him planning the robbery, why is that not enough?
He didn't say, I heard him plan something. I think he said, I heard him say, I need some money, I'm going to rob someone tonight, which is, I realize that's a small distinction, but, he had always said, I didn't know Mr. Fernandez was going to do this, I didn't plan anything with him, and I didn't have anything to do with it. I just think that to read a general denial as opening the door is just too broad a reading of this doctrine of curative admissibility.
I think that may be true, but I think the witness here by saying, we didn't talk about this beforehand, we didn't, and when the witness was going to testify to the exact opposite is there.
And my argument is simply that that it's a matter of degree, and if Mr. Garcia had gone on and on and on about what people talked about at Tina Buck's mother's house and what people didn't talk about at Tina Buck's mother's house, then I think you could have a witness come in and say, he has misrepresented what was happening in the house that night before they went to the Villar dos Oros. But in this case, he simply said, I didn't know about it, I didn't plan it. So I think it's a matter of degree. And our position is he didn't go far enough to open the door.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
May it please the Court, the State appears by Assistant District Attorney Jody Litvin. First, I'd like to hit on the first issue, which is the denial of his motion to suppress. And when we're looking at the voluntariness of a confession, we have to look at the totality of the circumstances. And hitting on the standard of review, it's true that this Court has, in some circumstances, taken a de novo standard of review when they're in the same position as the district court was in, and we do have the recordings here and the testimony or the transcript of those recordings. So,
how is that a credibility determination? Usually, we afford deference to the district court to assess credibility. To me, it sounds like she's observing the videotape to make her determination of how much pain is being experienced, and why is that entitled to deference, her observation skills over ours?
I think it's a factual finding made by the district court at that point. So I think that your role as an appellate court is not to reweigh the evidence, not to make factual findings. So I would say that it would be a factual finding made by the district court. However, you are I'm not going to disagree that you're in the same position. You can watch the videos, you can read the transcripts.
And we may be splitting hairs because if we watch the video and see more pain, then we could simply say the evidence doesn't support the finding.
Right. And under either standard, though, the state's position is that the confession is voluntary. So if we look at it through either way.
Could I move you to a different aspect of that?
Yes.
The detective here that was in the room would have had discretion on which crimes to book Mr. Garcia into jail on, wouldn't you agree?
Yes.
So he could have booked in on robbery and not the murder.
Yes.
And so when he tells girlfriend, go ahead and explain it to him, help me help him, and then the girlfriend says, they're not going to book you for murder. That's the quote. They're not going to book you for murder. Then the people in the room had the apparent authority to carry through with that promise, did they not?
Yes, however, I don't think he believed that they did. I didn't catch the distinction between booked and charged as well. I think my brief refers to it
but
as
that's
charging.
followed immediately with, all right, man, I did try to rob that guy. And then the girlfriend talks about, yeah, but he really tried to stop him from shooting the guy and all of that. But it's hard to read that without seeing that the defendant admitted participating in the robbery because his girlfriend says you won't be booked for murder if you do.
Based on his
how
statements.
can you read that without coming to that obvious conclusion?
I think there was conduct through the entire interview. I think we have to, again, look at the totality of the 5 hours that he was there. And I don't have the record in front of me, but I believe a couple of lines before that, he says, they're going to charge me on both of them. They're going to book me on both when I get down there.
And the DA lies. The DA
yeah.
lies all the time. I agree, but he did that for 3 or 4 hours and didn't believe, and then the officer brings his girlfriend in and his girlfriend and says, explain it to him. Obviously implying that I can't get through to him. You explain. She says, admit to the robbery and they won't book you for murder. He says, okay, I did it.
Well, I still would say that his statements 2 or 3 sentences before that were still doubting the ability that the officers had to book him in on that. I think just throughout the entire interview, and granted, I mean, he does admit to it later, but I would say that throughout his attitude, and he's just doubts. I think he doubts the authority throughout the entire interview. And the officers as well, they say repeatedly, it's looking that way. What choice do I have when he's asking, am I going to be charged with murder? He refers to it's the DA's authority to make the deal. I can't tell you what the deal would be. It's not my call. I believe there's just repeated statements made by the officer asserting that he does not have the authority to make the charges. And again, I didn't see the distinction between booked and charging, but I think for the defendant, it's the same. He would view it as being the same. Again, I don't know if I hit on
Well, there is a distinction. That negates your argument that a rational defendant would not believe the officer had the authority to make a charging decision. That's part of your argument, isn't it? That he didn't believe that the officer could do what the girlfriend is saying they were going to do.
Right.
But in effect, the officer did have that authority.
To be booked on, but I don't know that the defendant made that distinction as booking as opposed to charging. And I don't know if I hit on in my brief too. I believe this can be considered to be harmless error under the harmless error analysis. So we would argue that even if his confession was involuntary, if we look at Iman's testimony from prelim, and if we look at the rebuttal testimony, that this could still be considered harmless error.
What was the nature of the wound that Mr. Garcia, they said shot in the foot? Do you know what the nature of it was in terms of, was it hit? Was he bleeding? What was happening? Do you know?
As far as I can recollect, I believe he had treated it with some peroxide, and it was dressed. So I don't believe it was bleeding through the dressing. I know he had his foot up at one point, so there was some cotton balls or maybe something stuffed in the wound. And again, I think it's important to point out that he chose not to go to the hospital. And whether that's considered a denial of medical care now, it's important to realize that he had waited the 8 or 9 hours prior to being picked up for questioning and chose not to go to the hospital. So I think that's relevant.
You mean prior to being picked up, he chose not to go to the hospital?
Correct. And he also provided various reasons as why he didn't go. He was paranoid. He didn't know where the hospital was located. And at one point, it seemed like just getting patched up at his friend's house was good enough for the injury at that time. And again, if we look at the video, as the district court pointed out, he doesn't appear to be in visible pain. He's obviously not passing out. He's not going unconscious. He's coherent. He's focused. And the only times when it seems like he's focusing on the injury is when he's alone in the room. And of course, it's going to gain more importance when you're not being questioned and there's no interrogation going on.
Who makes the call when someone's in custody, when you suffer from a bullet wound, is whether treatment's necessary or not?
I guess that would be up to the officers at the time.
And how far can they go? That was the question of your opponent. How much pain does a person have to be in, and how serious does the injury have to be? And none of them are medically trained, so...
It's a very case-by-case basis, I would have to say. If we look at the cases that she compares it to, and where they've held that denial of treatment, among other things, has been held to render a confession involuntary, a man's shoes were held from him for days, 6 days, I believe, and there were sores on his feet, or people were in the, or a defendant was in the intensive care unit, unable to speak, hooked up on many different machines, or being withheld medication. So I would say in the spectrum of the cases that were cited, if we look at the video and look at his demeanor and his behavior, it doesn't compare to those. It's on a lesser scale, but I don't know if I can...
Kind of a hindsight necessary sort of evaluation, though.
Agreed.
Which means that somebody can be very seriously impaired by the delay in the meantime.
Yes, and I'm not doubting
trusting law enforcement. Does the record tell us anything about the treatment that he eventually did receive, or whether he was kept in the hospital or anything like that?
You know, I'm not sure if the record addresses. I know he was taken to the hospital.
In the briefs, okay.
I don't believe it does.
But you would agree that that is a form of coercion to tell a suspect in custody that you could not get medical treatment that you desire until we're done questioning you. And I understand you're arguing it's not so coercive as to render this confession involuntary, but it's hard to look at that without characterizing it as some form of coercion.
I don't know if I could disagree with that. I think that's true, that it is. If they're saying you cannot go to the hospital until we're done, until I get the answers I want, which is, again, not what I think happened here, and it didn't get to that level, I think that is coercion. If we want to move to the rebuttal testimony.
Do we know why Mr. Dos Santos wasn't identified until the eve of the trial?
I tried to find that in the record. I'm not sure as to why the notice was so late.
But the law enforcement had a statement for some time.
I believe that's correct. And it just wasn't brought to the attention of the court until late, and that's why he wasn't allowed to be on the state's direct or case in chief. However, I think in this case the appellant's arguing that rebuttal evidence, it's too narrowly arguing for rebuttal evidence. I think that when Garcia took the stand, testified, no, I didn't plan a robbery. I mean, he was directly asked, did you ever plan to rob anyone that night? No, I didn't. I think that that's specific testimony. I don't think that's a general denial. That's specific testimony that the state was allowed to, on rebuttal, come back and directly contradict with the evidence that showed he did plan a robbery for that night. And then going to the autopsy photos, just to note that it's rarely been held as an abuse of discretion in a murder case to have autopsy photos. They have to be relevant and probative, and I would say...
What is the relevance? What's the relevance of... I know Dr. Mitchell said he wanted basically to give an anatomy lesson, but, I mean, why was that relevant here? We have felony murder. All that has to be proved is that this death occurred during the course of the robbery. We didn't have to know the path of the bullet. We didn't have to know anything, just simply that there was a causal connection between committing the robbery and the death. And so what was relevant about the photos that depict a body that was altered by the autopsy procedure, surgically altered?
I would say that it proves the relevance that you have to, it doesn't lower the standard just because it's a felony murder case. The burden of proof isn't lowered to prove the cause and the manner of death. So I would say taken in aggregate, the photos show the cause and manner of death. And
how did Exhibit 188 show that?
You know, I don't know that 188 in itself had any value. But I don't think that one autopsy photo alone is an abuse of discretion. I would say the rest in total showed all of the gunshot wounds on his thigh, his back, and the damage to his liver and his chest wall. And those were relevant to showing the cause and the nature of his injury.
Even if one photo or two photos we find didn't have relevance but were not enough alone, that would go on the stack for the cumulative error, wouldn't it? I mean, we have that issue raised here.
Yes, I would agree that it would go on the stack. However, I would agree that there's case law that says if it's relevant for the coroner's testimony or the medical profession, the medical testimony, that it is relevant. So maybe it can't go to the cause or the nature of the injury, but if it's relevant for the person in explaining the medical testimony.
Why isn't that an abdication of the judge's gatekeeper role? Your opposing counsel suggested that the trial error is really just kind of an abdication of that role to the coroner. That anything he claims is relevant to explaining his opinion comes in. Even though the real relevance question isn't what's relevant to his opinion, but what's relevant to proving the elements of the crime. And you suggest that would be cause and manner of death.
Yes.
Which we've said many times.
Right.
So we're with you there. But I'm just asking, why isn't that an abdication? Just because the coroner wants to talk about it, as my fellow justice suggests, wants to give an anatomy lesson, why is that relevant to the case?
I would say that the district court would just have to take it,
There is a role there for the judge, isn't there?
Yes.
When the photos are challenged.
Yes.
I know that it's very rare for us to give any relief on this claim, but there's still a role there for the trial judge.
Yes, there is. And I would just say that they would have to take the coroner's opinion and weigh it and really weigh the photographs.
Did that occur in this case? I mean, do you know if there was any effort for the pre-trial or before these exhibits were admitted to look and try to sort through which ones may be redundant or repetitive, which ones weren't? Anyway, there's here are 5 autopsy photos. I'm going to let this one in. Was there any effort like that?
I don't know if it was raised in any pretrial motion. I know that there was, on testimony of the prosecutor, an abundance of photos, and this was only a small amount of the photos that were chosen to come in. And although I don't have the record in front of me, I believe that the district court, I don't know if they did not allow a couple of photos to come in. I don't know if they came in total.
Counsel, would you address the issue of cumulative error before you sit down? We've talked about these in isolation, but if you could kind of combine it, I'd be interested to hear your comments.
I think I hit on it slightly in my brief. Taken together, I think that it still does not meet the burden of having still does not meet cumulative error. Even with the confession, if you ruled all of them involuntary, or if you ruled I'm sorry, I'm losing my train of thought here. If you ruled all of these errors, all of these things were error, I still believe there is enough to show and to have these convictions affirmed.
My question is why?
Due to the evidence of the girlfriend who testified in preliminary hearing, and which was later admitted in trial, about the evidence that there was a plan to commit this robbery, and due to the witnesses that were presented at trial that talked about the plan to commit the robbery. I guess
Don't we have to discount the girlfriend's testimony pretty severely, given the number of stories she told and then the fact that she made herself unavailable to testify at trial?
I think there is credibility issues with the girlfriend, but out of all of the stories that she told, there was some sort of plan. I think she changed who initially made the plan, but I believe throughout her testimony there was a constant plan that there was going to be a robbery that night, and that they all understood that there was going to be a robbery that night, and that Mr. Garcia was a part of that plan.
Any further questions of counsel? Thank you, counsel.
Thank you, Your Honor.
You reserve 3 minutes for rebuttal.
Thank you. Justice Rosen, I believe you were asking me about the objections to the photographs. That can be found at volume 11, pages 521 through 522, 524, and 534. And the objection was to 163, 165, 175, 176, 177, 178, 179, 180, 182, 183, 188, 188 was the one I was talking about for the most part, 198. There wasn't a 198, so I'm assuming they meant 189 and 190.
And when that objection was made, is there indication in the record that the trial court looked at those and said no, or exercised some discretion on its admission?
I don't remember. I do remember that Dr. Mitchell said, these will all help me. And I think that that was the basis for the admission. There was no pretrial hearing on those photographs. And you know, as I was listening to the discussion about the bullet wound, it just kind of occurred to me that if Mr. Garcia had asked for a lawyer instead of a doctor, the questioning would have stopped. And I just find that kind of funny. And I was thinking back to a case I had many, many years ago. I'm not citing this to the court as dispositive of this case because I didn't cite it in my brief, so that wouldn't be fair. But I just recall arguing the case of Omar Valentine many years ago. And in that case, I think I had argued that it was error for the trial court to instruct the jury that a bullet wound was great bodily harm. And this tribunal, with different members at the time, disagreed with me on that. So that just strikes me as kind of interesting in this case. And I want to go back to the nature of the promises that were made in this case too. This court's always let the police tell a suspect, you know, things are going to be better off for you if you confess. I'll tell the DA you cooperated. You'll feel better. They're given a lot of latitude. But the thing they're not allowed to do is make a specific promise. Just confess to murder and you won't be charged with robbery. And it's very similar to the Swanigan case.
The other way.
I'm sorry.
Yeah.
Thank you. You're correcting me right and left today, Justice Johnson. It's very similar to the Swanigan case where we had a situation where a suspect was told, confess and you'll only face one charge, fail to confess and you're going to face 5 charges. And that was a case that this court found those threats and promises.
There was a great deal more involved in that case.
Well, that's true. Mr. Garcia isn't developmentally delayed, and that is a distinction.
Didn't they also, in swearing, and didn't they also lie about some of the evidence that they said they had?
Right, but you know, this court has approved that. and many courts have approved that.
But I think
it's
they
okay
were.
to lie.
I think the court was very clear in that case to say it was that combination of factors
Right,
in that
right.
case with the.
So I would say in this case, it's the combination of promise and throbbing bullet wound that has not received proper medical attention.
Ms. Wilson, a question about remedy. If we would reverse and remand for new trial, do we have any ability to prophylactically order the rebuttal witnesses to be excluded? Or is that just a matter of it goes back down and now there's no surprise to your client and it comes in?
Right. I wouldn't suggest to this court that you could keep Markel dos Santos out forever, since the sole reason for the exclusion of his testimony was unfair surprise to the defense. So I wouldn't suggest that as part of the remedy. Just the exclusion of the confession.
So does that impact our cumulative error analysis? Because if it was error at this trial, but it will come in, does that mean that we count that as part of the overwhelming evidence?
And let me add to that question, because I was wondering if even the harmlessness of that particular issue by itself.
I don't think, answering your question first, Justice Johnson, I don't think that affects your cumulative error analysis, because we're dealing with the trial as it occurred in this case.
What about
The fairness of the first trial.
Right. And, okay, can I get your question again, Justice Lukert?
Does that affect the harmlessness analysis on that rebuttal witness issue taken by itself?
I don't think so. And I don't think so because the defense counsel's trial strategy might have been different if they expected just by saying, I didn't plan a robbery, that Markel dos Santos was going to come in. I think that it was clear error to bring that in this trial as this trial occurred. And so I think when you're talking about harmlessness, you look at all the evidence that was introduced in the trial as it occurred, rather than look to a future trial where he might be fairly convicted rather than unfairly convicted. And so I think when you look at all the evidence that was in this case, if you take out Miguel Garcia's confession, if you take out, as you should in this case, a Markel dos Santos's testimony, then his conviction basically hangs by the slender thread of Iman Malkawi's credibility. And so I think then if you're determining harmlessness, especially in the cumulative error issue, I don't think that you say, well, at a new trial it could come in, so it's harmless in the trial that occurred. Because I think without the confession, without Markel dos Santos, the jury had ample reason to say, we're not going to convict someone of littering based on Iman Malkawi.
What about opposing counsel's assertion that, well, there might have been some inconsistencies in the various statements given by this witness, but consistent throughout all of the statements was this one critical issue? Can you respond to that?
When she said that, I was burrowing through my brief because I can't answer that off the top of my head. I think I recall her being more inconsistent than was represented, but I can't say that for sure without spending a little time looking at my brief again. And I was surprised, and I didn't have the time to look at that, so I can't answer that right now.
Your response to that question would be found in your briefs. There's no need for us to go back to the record independently and try to dig that out.
I know it would be in my brief because I addressed her testimony in harmless error analysis. So I know it would be in the brief.
All right, very good. Any further questions of counsel? I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement. This time, this court is in recess for 15 minutes.